Hey everybody, James Reeves, Esquire, believe it or not. I'm licensed in Florida, Mississippi, Louisiana, Alabama. I am the U.S. Law Shield Independent Program Attorney for Louisiana and Mississippi. If you need concealed handgun coverage that doesn't suck, that actually gives you coverage, where I've actually represented many clients who've defended themselves, have a look at U.S. Law Shield. If you use the promo code NGGC, like Neutral Ground Gun Company, my gun range here in New Orleans. If you use that code, you get a couple free months. I get like 20 bucks or something. We all win. We don't all win today, though. We actually had a pretty nasty ruling yesterday from the 7th Circuit Court of Appeals. Of course, 7th Circuit, probably the second most liberal circuit behind the 9th, possibly teeing this up for Supreme Court intervention. We're talking about short-barreled rifles and short-barreled shotguns. Again, this ruling came down yesterday. The 7th Circuit Court of Appeals just ruled that short-barreled rifles, or SBRs, can still be restricted under the NFA, or the National Firearms Act. This decision, U.S. v. Rush, leans heavily on the same flawed reasoning that courts have been using since the 1930s, that SBRs are supposedly more dangerous than other firearms because they're powerful and they're concealable. But here's the problem. This entire line of thinking is just nonsense. Not only is it based on outdated assumptions about firearms, but it ignores reality, modern gun technology, even the laws of anti-gun countries that don't regulate barrel length like we do. Let's refresh you a little bit on one of the most important Second Amendment decisions of all time, 2022 U.S. Supreme Court decision in Bruen, the Bruen case. That's New York State Rifle and Pistol Association v. Bruen. The Supreme Court established a new test for evaluating gun laws. Under Bruen, firearm regulations must be justified by historical tradition, meaning the government must prove that similar restrictions existed over the history of gun regulation in the U.S. The short version is that exceedingly dangerous and unusual guns can be regulated, but guns in common use can't be banned under the Second Amendment. In contrast, United States v. Miller from 1939, an earlier Supreme Court case that upheld the National Firearms Act, the NFA restrictions on short-barreled rifles, short-barreled shotguns. The court ruled that the Second Amendment only protects weapons with a clear connection to militia use, found no evidence that short-barreled shotguns were commonly used by militias, thus allowing for their regulation. Miller has since been used to justify a lot of different firearms restrictions, but Bruen has now changed the legal landscape by requiring a more strict historical analysis. So let's talk about the Rush case. Rush was charged with illegal possession of an SBR. In case you're wondering, I know you are, it was a 7.5-inch Anderson Defense AR-15. If you're a gun guy, like I am, you know that if there's one thing this dude's guilty of, it's having shit taste in guns. Going to jail for a 7.5-inch Anderson AR-15 is like being arrested for shoplifting from a Dollar General or getting busted trying to bang a 300-pound fatty prostitute. If you're going to go illegal SBR, at least make it something awesome, not the literal cheapest, shittiest SBR I can think of. Anyways, he challenged these charges. We're still pulling for him. He challenged these charges on the basis that SBR shouldn't be restricted under Bruen. The 7th Circuit upheld the NFA's restriction on SBRs, rejecting the argument that Bruen should invalidate these laws. The court relied on some key but incorrect points, that SBRs are more concealable than full-length rifles, making them more likely to be used in crime. That's wrong. SBRs more powerful than handguns, but they can be hidden like handguns, making them uniquely dangerous. Also wrong. Historical analogs support the regulation of concealable weapons. Maybe, maybe not, but not what the court uses in this decision. The court argues that SBRs, that's rifles with barrel length under 16 inches, or short-barreled shotguns, that's under 18-inch barrels, are too dangerous to be unregulated, too concealable to be freely owned. They're treating short-barreled rifles, short-barreled shotguns like machine guns. But here's why this makes no sense. Let's get one thing out of the way. The kind of people who commit crimes don't care about SBR laws. We know that. The only difference between an SBR and a braced pistol is the kind of stock it has. It doesn't make much of a difference. Criminals are not swapping freely between a brace and a stock before they commit a crime. They're not looking at their gun saying, oh man, I was about to rob this gas station, but this stock isn't legal. Guess I'll go home now. And they aren't even bringing rifles anyways to commit crimes. If they want to hold someone up, a criminal, they only need a handgun. It could be a .22. Rifles, assault rifles, responsible for about 3% of all gun deaths, and that isn't because short-barreled rifles are treated like machine guns. Again, if someone's going to commit a crime with a gun, they don't care about what kind of stock's on it. They don't care about what the barrel length is. Converting a legal braced firearm, a legal one, into an NFA regulated SBR takes seconds. Unlike machine guns, which require substantial modifications and parts, creating an SBR, simple as swapping a brace for a stock. Something that literally takes seconds and no tools. Okay, here's a little demo for you. This is an LMT MRP AR-15 with, I think, a 12.5-inch barrel, because legally it has to be over 16 inches, or otherwise it has to be an NFA item. In other words, I got to pay for a tax stamp and file a bunch of paperwork with the government to have this with a rifle stock. This configuration, 12.5-inch barrel, right, under 16 inches, but with this, a brace, even if I shoulder it like this is perfectly legal, right? This is a pistol. This is legally a pistol. Now, for those of you who don't know guns very well, get ready to have your minds blown, because this is incredibly silly. Do you want to see me make it a short-barreled rifle that would put me in prison for like 10 years? We'll do that right now. Boom. Now I'm going to fucking prison. Just kidding. This actually is registered under Form 1, and I've also got a manufacturer's license. So this is, in fact, a totally legal SBR. This, it's a regular firearm. This, it's treated like a machine gun. Do you see how quickly I can switch between the two? Do you think a criminal who's going to rob a gas station or shoot a bunch of people cares which one of these is on there? You guys are smart. I don't have to spell out how arbitrary this is to you. This short-barreled rifle, NFA, same thing as a machine gun. I got to do a bunch of paperwork. If I don't do a bunch of paperwork, I'm going to prison for a long time. This is no different than a regular handgun, a regular pistol. These are the same thing. Now, if this had either stock on it, but this barrel was 3.5 inches longer, now it's a rifle. If criminals wanted SBRs, they could just make them at home, just like that. And they wouldn't care whether it's legal or not. They don't want them, though. They want easily concealed firearms, so they just use pistols, completely unrestricted by barrel length. Handguns, 80 to 90% of crimes. In other words, the reality of criminality is that SBRs are completely on the table for criminals. It's just as easy to get an SBR as it is to get a handgun, but criminals don't want them nor use them. What about concealability? Yes, some SBRs are more concealable and more effective than handguns, but at the same time, they still stick out like a sore thumb. I'm gonna say that this is not only the sexiest gun that I probably own, but the most concealable rifle that I own. This is a Sig Rattler LT in 300 Blackout. Does this look very concealable to you? Does this look like I can shove it in my pants? Maybe I could convincingly get it under a very, very large jacket. This is not what criminals, oh yeah, I'm gonna go knock off the gas station with a Sig Rattler LT that costs $4,000. It's not practical, it's not concealable. There is literally nothing stopping them from getting an MCX lower or an AR-15 lower and putting a short-barreled upper on there. There's nothing stopping them from doing it right now. But criminals don't do it because it doesn't make sense. So they're not uncommonly dangerous. Now, let's look at this, technically, a short-barreled rifle, because this has a buttstock. The barrel is less than 16 inches in length. This is also really sexy gun known as the Flux Raider. This is perhaps the most concealable short-barreled rifle that I own, but it's not really a rifle, it's a pistol. You can see it's a SIG P320 with a buttstock on it. So this is literally, it's a 9mm pistol, and it's still quite large and bulky, not very concealable. So once again, this isn't something that and they're expensive. They're expensive. This isn't something that a criminal is going to be like, yeah, you know what? This is what I need as a Flux Raider instead of like the cheapest handgun I can steal out of someone's car. What I'm driving at, what's the point of the SBR SBS restriction? It's not stopping criminals, it's just making law-abiding gun owners jump through ATF hoops for no reason. A bunch of waste. This kind of judicial reasoning is straight out of like Reefer Madness, that 1930s propaganda film that tried to convince people that smoking the reefer would turn them into crazed murderers and rapists. There's no epidemic of SBR crime in the US, nor would there be. Again, criminals can make them right now. There's no meaningful distinction between a short-barreled rifle and a rifle pistol with a brace on it. They're the same gun. They just have a different piece of plastic on the end of it, and neither of them can be concealed well. The ones that can kind of be concealed are just pistol calibers anyways. This is a 9mm, and it's not very concealable. All the evidence, all the statistics indicate that short-barreled rifles and shotguns, despite how easy they are for criminals to get or make, they're not used in crimes. Assault rifles, semi-automatic rifles used in just 3% of crimes, shotguns less than 2% of crimes. That's short barrel and not short barrel combined. So they aren't any more dangerous than handguns statistically or from a concealability standpoint. They're certainly not harder to get, but remember, the Bruen standard is dangerous and unusual. Are they unusual like the Seventh Circuit says? No. One, a major flaw in the not in common use argument is that it creates a self-fulfilling prophecy. Certain firearms are rare not because lack of demand, but because the government has artificially restricted them for decades. SBRs are rare because the government heavily restricted them under the NFA 90 years ago. So courts argue that they can be banned because they're rare. But they're rare because they've been banned. Ironically, Justice Breyer pointed out this circular reasoning in favor of gun control because he's saying, oh my God, if someone makes these dangerous guns common, well, then at that point we can't regulate them. It actually works the other way. If the government bans a gun long enough, then it can just say the gun's unusual simply because people haven't been able to buy it legally for generations. That's not an objective or fair legal standard. It's just a circular consequence of past regulation. If common use is going to be the test, it should be based on what people would own in a free market, not what they're allowed to own under a century of arbitrary government restriction. Number two, they are common use. Short-barreled rifles, they're firmly in common use in the US military, especially. There's got to be a million of them, literally 500,000 to 1 million M4s. The M4 carbine issued to most branches of the military, 14.5-inch barrel. Legally, that is a short-barreled rifle, even though it's a frickin' huge 6 or 7 pound rifle. The Mark 18, the 10.3-inch barreled variant, so a little bit shorter, widely used by special operations, SWAT teams, other professionals because it's easier to maneuver in tight spaces like buildings or vehicles. That same maneuverability and that compact size, which make the Mark 18 effective in military and in law enforcement close quarters combat, would be logically just as useful, if not more so, for law-abiding civilians in home defense scenarios instead of a rifle with a big long barrel. And despite the perception that SBRs are somehow way more dangerous, the ballistics tell a different story. The Mark 18 10-inch barrel results in significantly lower velocity and energy compared to a standard 20-inch M16. 55 grain M193 5.56mm round fired from a 20-inch M16 barrel can achieve muzzle velocity around 3,250 feet per second, about 1,300 foot-pounds of energy. In contrast, the exact same round fired from a Mark 18 with a 10-inch barrel sees a dramatic velocity drop to about 2,600 feet per second, only 820, 830 foot-pounds of energy, a reduction of about 40% in muzzle energy. That means that while the Mark 18 more maneuverable, it's actually much less powerful than a non-regulated, regular rifle, full-length M16, making the idea that SBRs are somehow more dangerous than standard rifles completely baseless on top of everything else I've mentioned in this video. The reality is, SBR, it's easier to handle indoors, but substantially less powerful. But ultimately, you guys know this, the ruling's not about safety, it's political posturing and about preserving laws that make no sense in the modern world. Let's talk about how ridiculous this is also by looking comparatively at other countries far more restrictive on gun rights than the US. Canada, they had some major gun law changes recently, like the past few months, so I don't know what the deal is right now, but for years, short-barreled shotguns were pretty much totally unregulated. Unlike in the US, where a 14-inch barrel shotgun, you got to get a tax stamp, it's treated like a machine gun. A Canadian could just go to Walmart, buy one over the counter without the same restrictions we have. In many European countries, barrel length, not regulated at all. They focus on caliber, type, magazine capacity, not an arbitrary length requirement because it's silly. The point is, even countries that heavily regulate firearms don't obsess over barrel length like the US does. for some reason. But now let's talk about the most batshit insane part of this opinion. Arguing that these specific regulations I'm about to tell you permitted a traditional ban on SBRs. Regulations, quote, regulations on barrel length. A 1649 Massachusetts law, this is in the opinion, required musketeers to carry a good fixed musket not less than 3 feet 9 inches nor more than 4 feet 3 inches in length. Also cited in this opinion, 1785 Virginia law, regulating the length of militia members' firearms, providing that every non-commissioned officer and private shall be equipped with a good clean musket carrying an ounce ball 3 feet 8 inches long in the barrel. Oh my God. Oh my God. These are not regulations, they're not restrictions. They're a standardization requirement for a unit. If I'm fighting with a shitty musket, with a shitty bayonet, you bet your ass and I'm gonna have the longest barrel possible to get maximum range, accuracy, and terminal performance and maximum reach with a bayonet without making the gun too long or too front heavy to use. This is more of a, hey, you guys better bring a long ass gun with you, because if you bring some short barrel bullshit, you're gonna miss every shot and you're gonna get stabbed to death by some dude with an annoying accent and teeth like a goddamn billy goat named Worcestershire sauce or some shit. This isn't, hey, you guys can't have short guns because they're dangerous. It's the opposite. We want you to be dangerous. You need a longer gun. The Seventh Circuit, attempting to frame historical militia firearm length standards as analogous to modern barrel length restrictions under the NFA. However, these historical laws were about military efficiency, not public safety. This is the most disingenuous and logically unsound argument I've ever read in any court opinion ever, and that's as someone who clerked in federal court and who's been practicing law since 2009. This decision upholding the NFA's SBR restriction, legally weak, logically incoherent. Criminals don't care about barrel length. They can, if they want to, they can do whatever they want right now. They could go buy a 7.5-inch barrel, just like this Rush fella did, and they can slap a lower on it, and boom, they've got an SBR. They don't do it. They don't do it. They use handguns. Even anti-gun countries know this. They don't regulate barrel length like the US does because there's no difference. But this isn't about public safety. It's about preserving some outdated law written by people who fundamentally misunderstand firearms and how they work. If the Supreme Court eventually takes us up, hope they do, they'll have to decide whether we're going to keep pretending that barrel length makes a firearm more dangerous or if it's time to bring gun laws into the 21st century. I am not your lawyer. This is not legal advice. Let me know what you think in the comments, please. Do you think short barrel rifle, short barreled shotgun laws are good? Are they doing anything? Or is this just another useless regulation that will punish regular gun owners? I think both Ruby Ridge and Waco were actually started over short barrel rifles, short barreled shotguns. So think about that. Could be wrong on that, but double check me. Guys, thanks as usual for watching and take care.